or the other. It's time. This was indicted in December of last year. 7 months have gone by.
Yes.
What are we gonna do?
Let's set it for the trial.
It's set for trial, period, in the ballgame. That's what we're gonna do. Special set that as soon as we can, okay? We'll get, it's, that's the way it is. There is no deal. We just let a jury decide. Okay. It's on Clark and Charles Johnson.
Mr. Johnson's right there. Mr. Johnson, come up.
What are we doing on this one?
This one is a trial for sure. There's no negotiating this.
Do you still live on Crow Road?
Yes, sir.
Okay. It's 4235.
Yes, sir.
How long have you lived there?
August or September, like 3 years.
Okay. You're a Beaumont resident? You grew up in Beaumont?
Yes, sir.
Okay. What's your criminal history on this? I don't, there isn't anything on the indictment of criminal history.
Priors, but all these anything there.
Anything that's enhanceable?
I have two state jail felony convictions that I'm looking at, so that means he's not eligible for probation from the jury,
But it's
but
not.
it's not an enhancement.
What are the prior convictions for?
Judge, they are for possession of controlled substance back in 2006, as well as another possession charge in 2009.
Okay. I'm reading the,
Not over it.
Raise your right hand, please.
okay.
Swear or affirm.
The complainant in this case, do you know the complainant in this case, Nisha? You can't have any contact with her, you know that.
Yes, sir.
If, okay, all right, because I know, we all know what happens all the time. And we catch people all the time. They do things they're not supposed to do. And then the complainant victim in this case feels guilty about the whole thing, which is all backwards. That's not the way it's supposed to be. I don't want any influence on this person. She, according to his probable cause affidavit, went through hours of torture. And the jury ought to know this. You're not eligible for probation. You're looking at up to 20 years in prison. Do you understand? We're going to try this.
Yes.
And if I find out that she is reluctant because anything you did, your bond will be revoked and you can sit this out in jail until we get around to it. Have y'all talked to him?
This is Mr. Boyd's case, Judge.
Somebody ought to do that because
Yes, sir.
I sense I sense a whiff of an issue here
Yes, sir.
that we know what doesn't put up with. It's trying to influence the process illegally. Let me just catch it and deal with it severely. I'd like her, I want to know what her input is for y'all, with y'all right now on where it is, and that he hadn't tried to influence her or contact her. No,
Yes, sir.
because we'll have him up here and then he'll be put away until we can get around to the plans.
Yes, sir.
Get a resetting for trial. Felder Williams, please.
So there's no come back right back to that one. So that's the one who's just now found confident. So I just yes, you're you're right there. Right. So it's not, I don't know if we need to bring him out and rule that he's confident now, but this is something we just gotta report back saying he's confident. But silicon barrels back. So I'll run that up.
Felder Williams, please, Felder Williams, 23 CR 1723. Thank you.
I approach this, Judge.
What's up?
You will be free in the case that I have,
When?
as soon as I get him signed up.
Okay, I got a jury coming in
Yes,
5
sir.
minutes, but try to see what you can do.
Yes, sir.
We just So do we have some fires there? Yeah. So what does this do? Let's. Unlawful carrying of a weapon on 2006. After that became final, committed to felony robbery sentence. You are Felder Wade Williams
Yes, sir.
in cause number 23 CR 1723. Mr. West, John West here is your attorney, correct?
Yes, sir.
As you know, you were charged with the indictment of evading arrest or detention with a motor vehicle. It's a third-degree felony, which means you face up to 10 years in prison. However, you have some prior convictions here. You have an unlawfully carrying a
Barcelona-
weapon charged on a licensed premise out of this court in January of 2006. That's before I was a judge here. And you were convicted after that became final. You committed the felony of robbery of a second degree felony and were convicted of that in June of 2007 in the court next door. So if all of this is true and correct, you are what we call a habitual felon, which means if convicted of this third degree felony, and if all of these other prior convictions are true in the indictment, you're looking at a minimum of 25 years in prison up to life in prison. Do you understand what you're facing? Do you understand what you're facing?
Yes, sir.
Okay, serious. Life in prison. And that's, as you know, if you commit offenses and you keep committing offenses, the punishment gets higher and it gets more severe. Now, based upon concerns to the court about the defendant's competency, the court ordered that an evaluation be done. It was sent to the University of Texas Health Science Center at Houston.
Put her down pretty bad.
Was admitted to the facility in January of this year. And as he was found incompetent to stand trial. And the court has received a report dated July 16th, 2025, which consists of 8 pages. And have the parties had an opportunity to review that report of the analysis of this defendant? It's actually consists of cover page, 8 pages of a report, as well as an attending physician's report of 3 pages. And then, so that makes approximately 13 pages? 12 pages fully of the report. And we're going to call that Court's Exhibit 1 today. If the parties had an opportunity to review it, any corrections or changes or additions to it?
I reviewed this on Friday, Your Honor. Yes, I have no additions or changes.
I'm reviewing it now, Judge. I don't see any objections, no changes.
It is Hey, Jim. I got a gift for y'all.
Thanks, Josh. We're always like,
The problem is it's the same color
yes, sir.
10 years.
as
I didn't know what they was telling about.
You're different now than we're there. That's why we're here right now. Okay.
Or they still in a little off. It's gonna fall.
Right now, the officers do. I'll talk to you in a second.
Oh.
Nice.
all right, that package is referred to as Court's Exhibit Number 1. It will be made a part of the record for all purposes. Does anyone wish to add anything to this? No,
Not from the
from
state.
state or defense? All right, the analysis is that the court has received this and the defendant is deemed competent to stand trial upon this evaluation. And it will be set for trial. And do you understand, again, sir, you are looking at a sentence if convicted of this indictment, what's in this indictment? No less than 25, no more than years in prison, up to life imprisonment. And also,
It's just.
this is not an aggravated case.
No.
But that, when you're looking at life in prison, that is not the most important concern. All right, where are we on this?
We have an offer, but now that Mr. Williams is competent and can actually communicate with us, if we get a little more time, I can probably get this resolved.
How much time do you need?
Uh,
I mean, I think he's been thinking about it. I mean, we're talking,
Well, I would say set it for 3 weeks, since I'll be out the next 2 weeks.
what is,
10 years is the offer. And he said 25 life. Yeah. And I'm gonna talk to him in a second. I can change his mind. Wants to do it today. We'll do it today.
what do you want to do? Have you thought about it? Have you had the chance to think about it? I'm asking you, did you know about the offer? No? Okay, you get a chance to think about
Yeah,
it.
yeah.
You have a
I
fair,
understand.
You don't
yes, sir.
understand all
You,
the.
you have a fair opportunity to think about it. How much time do you think y'all need?
Well, like I said, Your Honor, I'm gonna be on vacation for the next 2 weeks. So if we can get that week I get back, which is the 11th, things worse, be fine with me.
Except for the 11th.
Yeah.
Of
August.
August?
Like I said, I'm leaving on vacation on Friday.
All
so I'll
right,
be gone.
you can make a decision by then, one way or the other, and then we'll live by it. We'll go one direction or the other. Okay?
Yes.
All right, work with him. He's a good man. All right, so that case is reset. What else, John? I was spelled. Oh, yes, sir.
I believe. Yeah.
Come on up,
Leon.
Mr. Coleman. And then David's working on something, isn't he?
Yes, sir.
That jam could be already.
Well, we now call 24 CR 1887, the state of Texas versus Dustin Coleman. You are Mr. Coleman. And you are here with your attorney, Mr. Comerford. Where is your office?
Austin.
In Austin? No. Spent some wonderful years there, postgraduate work, and yeah, beautiful city. Spent a lot of time in the old country. Boy, they've had some terrible things with the water.
Very sad.
You know, a place near there, and it was nice to get some water, but not over,
Yeah, too much.
no overreaching. The Pedernales, I couldn't get over the Pedernales that weekend. It was a raging a raging torrent. It was terrible, but could have been worse. But they need water and just, I'd like it in a fair sequence, not overwhelming. Sure. Okay, in 24 CR 1887, does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes.
In summary, sir, this indictment, as you know, alleges that on or about June 23rd, 2024 in Jefferson County, Texas, you committed the state jail felony of criminal mischief. Do you understand what you were charged with here, sir? What's this?
We're pleading to a class A misdemeanor, Your Honor, the lesser included.
You too?
Yes.
We are. Okay, as you know, State jail felony, if convicted, means you face no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
Now, the lesser included offense is what?
It's the same thing. It's just the amount would be more than $750, but less than $2,500.
And what's the plan? For what's the disposition?
2 years deferred probation on the Class A misdemeanor.
And restitution?
Yes,
Is in how much?
$2,560.
Is that it?
Yes.
Yes.
Okay. An agreement has been stand by. Has been made where you will be pleading guilty to the lesser included Class A misdemeanor of criminal mischief, which is is it less than 2,500?
Yeah, that's more than 750, but
More
less
than,
than.
okay, I want, yeah. Everybody has problems writing on this pad. I'm gonna write it in English.
It's worse for lefties.
That's your excuse.
Yes.
I've only been one since birth, and I know what you mean. All right. You were facing again up to 1 year in jail and or up to a $4,000 fine. That's what's normal for a Class A misdemeanor. Is that your understanding of the plan you will be pleading guilty to in this criminal mischief, lesser included offense?
Yes, sir.
And you would be placed on deferred or unadjudicated probation for up to 2 years, ordered to pay restitution in the amount of $2,560.18 to the complainant in this case as indicted. And there would be other terms and conditions of probation which are normal and customary for this type of case. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case, sir. Do you understand?
Yes, sir.
How do you plead to this lesser included Class A misdemeanor under this state jail felony indicted case of criminal mischief? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I'll show you what's marked as State's Exhibit 1. Did you sign that document? Did you understand it? Discuss it with your attorney? Or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence
Okay.
and without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You are guilty of the crime charged or, most importantly, any lesser included offenses, such as the one you were pleading guilty to that the parties have agreed to resolve this matter in that way. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true. This court finds this is true according to you, so help you God. Correct?
Yes, sir.
States Exhibit 1, part of the record for all purposes. Pre-sentence reports made.
Yes.
I'm going to follow this agreement, if nothing further, and find you are pleading guilty voluntarily, knowingly, intelligently. You are mentally competent to do so. There's enough evidence here supporting your guilty plea from States Exhibit 1 admitted to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to defer any finding of guilt so long as you follow these terms and conditions of probation for 2 years or less. You do well, you can get it shortened. There will be terms and conditions of probation which are normal and customary for this type of offense, including you must pay restitution in the amount of $2,560.18, which goes to the complainant as alleged in the indictment in this case. And then there are other terms and conditions of probation, which are normal and customary for this type of offense. Please follow this. It'll pass fast enough. Then you can move on with your life without a criminal conviction. In this case, if you fail, your probation could be revoked. You could then be found guilty and sentenced up to 1 year in jail, which nobody wants in this case. Quicker you pay restitution back, and we can dismiss it in a third. So you can do the math on 2 years. What's that? 24, 30, 24, it's 8 months. So, and I'm happy to do that if everybody agrees that's the right thing to do. Okay. Please see the probation officer. Thank you.
Thank you.
Yes, sir. Take care. Thank you. Be careful.
Will do.
Then I've got David on Keeler Maldonado, right? All right, Dennis, please tell the jury that we're waiting on finalizing some other matters, and we ought to be ready, hopefully within 20 minutes or so. If they can relax, stretch your legs.
Afternoon.
Here, this, I better keep this.
Singh Somal, 25W39129. Good morning, Mr. McDermott. How are you?
Good morning, Judge. Good, thank you. We do
You're-
have a resolution. I have authority to plead to the amended charge of impeding traffic. Request 2 weeks to pay.
All right, and I need your appearance. I'm sorry.
Sean McDermott, P46101, on behalf of Mr. Somal.
All right, to that charge of impeding traffic, responsible or not responsible?
Responsible.
All right, I'll accept the plea, $200. I'll give until August the 7th, okay? Have a good day.
Yep, you as well, Judge. Good to see you.
You too. Bye now. All right, Sierra, Amanda Serrato, Sierra, 25W39111. Could I have seated up here Jacob G. Neely, right over here at the table, my right, your left, and Popovsky seated there as well.
Good morning, Judge. Matthew Gifford, on behalf of Ms. Sierra.
Your name?
Amanda. Amanda Serrano Sierra.
She's going to plead to impeding with the unlicensed to be this drive while unlicensed to be dismissed. True?
Correct.
Have a seat, sir. You can have a seat right there. Right there at the table. All right, to that charge impeding, responsible or not responsible?
Responsible.
Okay, I'm going to accept the plea. 250 is your total. And you are all set, and you can go down the hall and pay that, okay? And you have that now, right?
Yes.
Good luck. Guy Neely, come on up to the podium, sir. Jacob Eugene Dwayne Guy Neely, 23W838-903 A and B. Your name, sir?
Jacob Eugene Dwayne G. Good morning, Judge. Matthew Gifford, on behalf of Ms. Neely.
Does he stand mute, waive formal reading on each of these charges?
Yes.
Not guilty, pleas entered on the false ID as well as the suspend personal bond $500. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We're gonna give you a new court date.
Judge, can we request 30 days? He's got-
Okay, 4 weeks, I'll give him, absolutely. He's gotta take care of, he's got other cases, I guess, tomorrow.
That's-
What do you have, Lisa?
August 20th at 8:30.
August 20th at 8:30. You need to fill out a petition for a court-appointed lawyer going forward, okay? So we'll have you fill that petition out before you leave. Maybe you can hand him one. You can sit down there, fill it out, and then you'll come back. Good luck. Thank you. Gabriel Christine Popovsky, 25W838818A. Is this yours or somebody else's?
That's not mine, Judge, no.
Who's your lawyer?
Crawford.
I thought we were gonna get Mr. Crawford in here.
I called him, what's his number, Judge?
I don't know, he's,
I think.
does anybody not have Mr. Crawford in here that's got a case ready? Hello? Anybody? What's your name?
This bottom one, Mr. Walker.
Ma'am, have a seat right behind you, okay? Noah Ryan Lohr. 25, right there. There you go. 25W839130, A and B. Come on up to the podium, state your name.
No problem, Lord.
You're charged with drivewall license expired. You're also charged with no proof of insurance. You have the right to a lawyer. If you want one, I'll give you one.
I have the insurance covered.
You want a lawyer? I can't hear you.
No.
I'll arraign you on my own, and then you can go talk to the prosecutor or tell me you want a lawyer. On June 27 and 25, it is alleged that you were operating a motor vehicle, or we're at, I should say, 22753 Allen Road in the city of Woodhaven, that you had an expired license. That's a misdemeanor punishable by up to 100 fines, 90 days jail, costs are all those in 2 points. And you also have the second charge and no proof of insurance. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
You still wish to waive your right to a lawyer? I can't hear you.
Yes.
I'm entering a not guilty plea, $100 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Do you understand all that?
Yes, sir.
Go out in the hallway, he'll set you up with the prosecutor. You speak with him. If he doesn't give you what you want, you can come back and ask me for a lawyer.
Thank you.
Gabriel Christine Popovsky, 25W838818A.
Good morning, Your Honor. Michael Crawford, representing Madam Station and Director.
Gabrielle Kowalski.
All right, so your client pled guilt, no contest due to a lack of memory to this charge of disorderly person, public intox. She was referred for a screening and assessment. Would you have the opportunity to review the report with her? I need a, and are there any material additions, corrections, or deletions?
I have had the opportunity to review the report with my client, Your Honor. There are no material additions or deletions that we're asking my client. We she can comply with the order, so we ask that the order be, the recommendation be entered as an order.
Ma'am,
Yes,
is there anything you would like to tell me?
that will never happen again.
What in the world was going on that day?
Intoxication.
Yeah, I know, but it seemed to,
Well, Your Honor, my client had a lot to drink, and she doesn't remember that, well, yeah, she knows she had too much, and she had an interaction with a guy acting inappropriately outside of the restaurant that led to this charge.
how old are you?
34.
You ever been in trouble before?
No.
All right, I'll go along primarily with this recommendation. 8 months probation, you cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I'm going to order that you attend the Substances of Abuse Group through Class A Training Center as recommended. Okay?
Okay.
Now, I'm going to have you test. I'm going to have it monthly for 3 months. If you're clean, I'll then make it on demand. Okay?
Okay,
So chemical testing, submit the chemical test PBTs and ETGs monthly for 3 months. If you're clean, I'll then make it on demand to probation. Okay?
thank you.
1-day court work program, 2 days of community service by September 15th. There's 1 day on the court work program, which that's $35. You're gonna attend that, complete that. $100 fines, 100 costs, 75 victims' rights fee, $50 justice assessment. 3 1/4 probation fees are $160 for 485. You have a screening fee of $60 for 545, attorney fees of $40 and then $35 in court work program fees. Everything included amounts to $620. Give me 1 second here. They did not, there was no 771 or anything on this, was there? Okay, all right. So do you fully understand the sentence of the court, ma'am?
Yes, sir.
Do you have all of that to pay?
No, Your Honor, my client would like to propose a payment arrangement. What she can do, Your Honor, is spend $100 today, and then she'd like to pay $100 every 2 weeks, consistent with her pay period starting August the 8th.
All right, the other thing I want to indicate is you're not to go near 21,000 West Road in Woodhaven. Do you understand that, ma'am?
Yes.
And I will abide by that request for payment. So I'm going to have you pay $100 today and then $100 bi-weekly starting August the 8th. If you need more time, come talk to me. Or if you're not in the area, call the court. You can either do it by Zoom, if you call the court and say, I need to talk to the judge about an extension, or if you're around here and you want to come in, you can do that instead, but it has to be on or before the due date, 8:30. Any questions? All right, you'll meet with probation, go down and pay your 100, then go across the hall to probation. Good luck. Robert Lewis Thornton Jr., 25W837260.
Good morning, Your Honor, Mike Hill Crawford, representing the defendant, stands to my right, sir, state your name.
Robert Lewis Thornton.
All right, so he pled guilty to resist and obstruct an officer. You got warrants all over the place.
Your
Have you
Honor,
reviewed the pre-sentence report with him, and are there any material additions, corrections, or deletions?
I have reviewed the report with my client. There are no material additions or deletions, Your Honor. We'd ask the court accept the recommendation as presented.
You know, they talked about 771.1. That was agreed to for 12 months. Probation's recommending no probation. Does he want to take advantage of that and be placed on probation, or does he want me to adopt the recommendation of the court, of the probation department that says no probation, just court work and fines and costs?
Your Honor, give me 1 moment. Your Honor, my client would like to take advantage of the probation opportunity.
Okay. All right. What would you like to say, sir? Anything?
No, thank you, sir. I just appreciate the help.
Your Honor, the court should know that my client has spent upwards of $500–600 addressing a lot of those warrants, and he's in the process of clearing it up. He knows he's got some work to do, but he started the work, Your Honor. And as he said, he's appreciative of this opportunity. He wants to protect his record. So the court can be as lenient as possible. He'd appreciate it. It was a tough day that particular day. He was upset, and he was being unreasonably uncooperative with the police. He understands that he won't do it again.
Anything else, sir?
That's all I'm saying.
I'll take this under section 771.1 for 12 months. You cannot leave the state without the consent of the court or violate any law. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. You're to clear all of your warrants by August the 25th. I expect all those to be cleared by August 25th. You're going to serve 1 day on the court work program and pay $35 for that. You're going to serve 1 day of community service by September 15th. So again, you cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. I want you to stay out of trouble, okay?
Yes, sir.
I'll take it under 771.1, clear all warrants before August 25th, serve 1 day court work, 1 day community service by September 15th. You do all of that, and you also not to go near to, that's the Siegel Chiropractic Clinic, not to go near 21631 Allen Road in Woodhaven. I'm going to kind of go light on the fines. $100 fines, 50 costs, 75 victims' rights fee, $50 justice assessment, 40 in attorney fees. So your fines and costs are $315. Probation fees, well, you got to pay the screening fee of $60 and the court work program fee is of $35. So, let me see. 410, you do have probation fees of $160, your total's $570. You pay that, you stay out of trouble. You do the court work, clear your warrants, do your community service. Again, stay out of trouble, stay away from 21631 Allen Road in Woodhaven. I'll give you a review date, you pay your fines, I'll dismiss the case. On motion, the prosecutor. What do you have as a review date?
Was it 12 months, Judge?
Yes.
You charged.
They only do 160. I'll tell you what, I'm going to reduce them. I felt maybe that's why I did it subconsciously. I'll reduce your probation fees by $80, sir, to I'm going to reduce his probation fees from 240 to 160. But it's still 12 months, so.
July 8th of 26 at 9 o'clock.
July 8th at 9 a.m., okay? Of 26, you'll have to come back for your review hearing and I'll dismiss it. Does he have all this to pay?
No, Your Honor, but we do have a payment plan to propose. He can pay $100 on July the 28th, and he can pay $100 per week thereafter.
$100 by July 28th, $100 weekly beginning August 4th. Can you do that?
Yes.
Okay. If you ever need more time, call the court. We'll go on Zoom or come talk to me on or before due date. I'll be glad to give you an extension, okay?
Yes, sir.
You'll meet with probation, you go meet with probation now. Good luck to you.
Thank you.
Thomas Patrick Abraham, 24W833005B.
Good morning, Your Honor. Michael Crawford, representing Mr. Abraham, who's approaching. Please state your name for the record.
Thomas Abraham.
I don't even know what good it's gonna do to put him through. He's had opportunities to get himself some help in the past. He just doesn't seem to do it.
Well, Your Honor, he's committed to follow through on things. He understands.
What are you still fooling around with this stuff for, sir?
I just made a few bad choices, Your Honor. I just want to, get it right now. That's all. I'm trying to close on a house and I just want to, put this behind me.
I know, but you gotta get yourself some help. You can't keep doing this. You just can't keep doing this. I mean, what am I supposed to do? He's had other opportunities. He said other opportunities to stay away from this stuff and to get himself some help. He's got a warrant out Westland for a drug offense. He's had an impaired, an OWI, a drug charge, an order, allowing an intoxicated person to drive, armed robbery. Armed robbery. He's on parole for probation or parole for armed robbery. Did he get any time on that?
You did serve some time, yes.
How long?
64 days.
That's all?
Yes, sir.
Armed robbery is a life offense. I don't need to know the specifics. I trust. Good morning, Mr. Urick. Nice to see you. How are you?
It's a privilege to be seen, Your Honor.
Good to see you. Your name?
William Urick on behalf of the city of William.
All right. I don't know what to do with him. I'm going to be completely honest with you. I don't think you're going to comply with probation.
I would appreciate the chance, Your Honor.
All right. What do you want to do? Is there anything you'd like to say on his behalf?
You know, nothing other than the fact that, again, my client is really making renewed efforts to improve himself. Like you mentioned, he's trying to closing the house, which is around the corner, he's coming into this community, Your Honor. He realizes he's too old for this silliness. These type of shenanigans can't keep going on, and he's trying to improve, the rest of the life of the years that he's got left. He doesn't want to keep being right up against Your Honor. Give him an opportunity. I think he's more earnest and serious about it this time, Your Honor.
I came down.
Exactly. Face up to this one.
Anything else you'd like to say? Either one of you?
No, Your Honor.
Sir?
No, Your Honor.
I'll tell you what, you didn't have anything to add on this, did
Negative,
you?
Your Honor.
You cannot, 15 months probation, they're recommending 18. I'm gonna see how he does. 15 months probation, you cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those things. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to clear all your warrants within 45 days. You are to attend an intensive outpatient treatment program at a facility approved by probation. You have to go to AANA at least 3 times a week until you're in intensive outpatient treatment. Once you get in intensive outpatient treatment, you no longer have to attend AA or NA. Clear all your warrants, as I said, within 45 days. I'm going to have you do 5 days of community service. 5 days of community service, that has to be completed. I'll give you all the way until October 1 to complete that. Fines $100, costs $225, $75 victims' rights fee, $50 justice assessment. So fines and costs here amount to $450, screening fees $60 for 510. You have $300 in probation fees. Everything included is $810 plus your attorney fees. Your total is $850. If you violate, your probation could be revoked. You could be jailed for 90 days. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand all that?
Yes, sir.
All right. Can he pay all of this today, or does he need time?
Your Honor, my client needs time. We have a proposal. He's on a fixed income, Your Honor. He can pay $200 today, but the court knows he's taking this seriously. But all he can afford to pay is $100 a month.
That's okay. $200 today, $100 a month. We'll start that beginning August the 10th of the 10th of every month thereafter. You'll meet with probation. Good luck. Thank you. Rogers. Wayne Michael Rogers, 25W83865A and B.
Good morning, Your Honor. Mike Hill Crawford, representing the defendant, to my right. Sir, state your name, please.
Wayne Michael Rogers.
So he's going to plead to allowing an unlicensed driver to drive. And we are going to then dismiss the equipment violation and suspend on motion of the prosecutor. True?
That's true, Your Honor.
If you do that, sir, the possible penalties are up to 500 fines, 90 days jail, costs are all those. If you plead to that, and I'm talking about allowing an unlicensed driver to drive, I'm then going to dismiss the equipment violation and suspend. You understand that?
Yes, I understand it.
And did you sign, read, and understand an advice of rights form here today?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a trial. Do you understand that?
I understand.
To the charge, allowing an unlicensed driver to drive, how do you plead? How do you plead?
Guilty?
You sound like you're asking a question. Do you want to plead guilty?
No,
You don't want
Not
to plead
guilty.
guilty? Pardon?
not guilty.
You want to plead not guilty? You want to go to trial on the suspend and equip?
No, I don't.
Well, what do you want to do? I mean,
I'll plead guilty then.
slow
I
down.
understand.
Hang on a second. Let's just slow down. Maybe I'm going too fast. Do you want to talk to your lawyer further?
Yeah.
Have a seat right there. Thank you. Jose Luis Silva Murillo, 25W8390918, and B and C. Your name, sir?
Sorry.
Your name?
Jose Luis Silva.
Can you understand me well? You understand English?
Sorry, sir, I don't speak English.
Let's get an interpreter on this one, Lisa. You don't have I saw another interpreter walking around here today. We don't have one today on him, do we, Lisa?
I don't believe it was him. Let me double check.
Yeah, this is his first appearance. I'm gonna get you a Spanish interpreter. I'm gonna have you come back.
Okay.
I know it's hard for me to communicate when we're gonna get you an interpreter. Interpreter. Do you understand me?
Yeah.
So we'll get him an interpreter. We'll reschedule that. I'll let you go down the hall and my judicial clerk will give you a new date. Okay?
So,
All right. And then we'll see you back here. Okay?
okay.
Best of luck. Wayne Michael Rogers. Did they go out? Okay, good enough. Alexandra Wolf. 25W839121. Where's Ms. Wolf at? Is she not here? She's on Zoom.
She's coming in right now.
Ms. Wolf, can you start your video and tell me your name, please?
Alexandra Wolf.
Okay. You're charged with parental responsibility violation. Do you want a lawyer?
No.
It's alleged that you violated parental responsibility law by allowing your daughter, your unaccompanied juvenile daughter, to take a bus from Pennsylvania to Michigan, where the juvenile had no support or supervision. It does not indicate how old the child was. That is a misdemeanor punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes.
You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to a trial by court or jury, right to question their witnesses, right to bring in your own, right to use the subpoena powers of the court to bring in those witnesses, and the testifier remains silent. If you remain silent, that silence would not be held against you. Do you understand that?
Yes.
You still wish to waive your right to a lawyer?
Yes.
I'm going to enter a not guilty plea. I'm going to indicate that you stand mute. I'm going to give you a $500 personal bond. You don't have to post any money. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'm going to send you to talk to the prosecutor. We're going to put you in a breakout room, and as soon as the prosecutor is ready, he will speak to you, okay?
Okay.
So you just wait in there for now, all right?
Okay, thank you.
I wish you well. Good luck.
Thank you very much.
Either way, you're coming back in front of me today, okay?
Okay.
Thanks. People against Dwayne Johnson. Dwayne Montiel Malik Johnson, 25W838974, A, B, and C. Mr. Johnson, come on up here and tell me your name.
Dwayne Johnson.
You're charged with driving on a suspended, speeding, and no proof of insurance. You have the right to a lawyer. If you want one, I'll give you one.
Yes.
Okay? We'll send you to a lawyer. okay?
Okay,
And then you'll speak to the lawyer and you'll come back in front of me, okay?
okay,
Thank you.
thank you.
Barton. Kelly Lynn Barton, 23R 513-503. Ms. Barton, you can come up here and tell me your name.
Thanks, Kelly.
You're back again.
Yeah, I didn't know I had a warrant, honestly.
You're charged with failure to refrain from consuming alcohol or drugs, testing positive for amphetamines on a chemical test of May the 19th at 25. That is a misdemeanor. I'm sorry. That's a violation of probation. You have, or they think you had a violation of probation. That's 6. You have 6 prior technical violations. You could have your probation revoked on this. You could be jailed for 93 days. Do you understand that? Did you sign an advice?
She was a walk-in, so I think she should have the arraignment attorney.
Yeah, I'm gonna give her one right now.
She should have already spoke to him. She was a walk-in.
Did you speak to a lawyer?
I spoke to somebody in that room over there. I don't know.
Oh, okay. All right. Do you know who you spoke to though? Well, was it a man
Yeah, it
or?
was a man.
Well, you'll recognize him, right?
Yeah.
Okay, so we
Tony
need you,
Carmen today.
we need you to go find him and then I'll go ahead and give him that. Okay. Okay? Thank you. McCullers, Brandon Keith McCullers, 16F2222. 858. Ann B. McCullers, your name, your name.
Brandon McCullers.
To what do we owe this honor and privilege?
I'm walking in on a warrant. I'm trying to clear up.
How old's the warrant? How old's the warrant?
There are a few of them. I think the oldest one is 2016.
Yeah, right. That's what I have. Where you been?
Yeah, I've been.
You been fighting in a war somewhere overseas? I mean, what have you been doing? 9 years, seriously?
No, Your Honor. At the time, I was working at Flat Rock Assembly Plant. I went through a divorce after that time and went through.
Let me get you a lawyer right now, okay?
I did speak with the gentleman. I believe that's the arraignment lawyer, if I'm not mistaken.
What do you look like?
It's Mr. Carmen.
All right, let's get Mr. Carmen in here on this one as well. Have a seat. I'll be right back with you, okay?
Yes, sir.
So I need Mr. Carmen. I need Tony Carmen on Barton and McCullers. Carmen on Barton and McCullers. What's your name, ma'am?
Me, Michelle Zanardi.
What, you have her on docket?
I do. She's a client.
What? All right, let's go on McCullers. Brandon Keith McCullers. 16F222285A and B. Mr. Carmen, your name?
Michael A. Carmen, 37324 on behalf of the defendant.
Name, sir?
Brandon McCullers.
What are we doing on this?
Your Honor, I believe this is a couple different, two.
He's got a driving on a suspended and he's got a possession of a controlled substance charge. These emanate from a December 3 of 16 incident.
He's gonna stand mute, wait the formal reading.
I hope he's got some money with him. I really do. Where do you work?
Currently I work at Pratt & Whitney in Lansing, Michigan.
Well, I hope you got some money. If not, you're gonna be sitting in jail. You can't do this, okay? You can't come to pretrial, schedule it for bench, and then not show up for 9 years. If there's some judge somewhere somehow that thinks that this is okay, I hope you find him when you play this little game next time. 4,010%. You cannot leave the state without the consent of the court. You cannot violate any law. You must appear in court as directed. I hope you have the money. I truly do. Do you have the money?
Yes, Your Honor.
You come here tomorrow, July the 24th at 9:45. If you miss tomorrow, next time I will set the bond at 100,000 and I'm gonna set it way down the road. You got it?
Yes, Your Honor.
Your Honor, that's on both cases, correct?
Correct. I'm only setting one 4,010%, and that's on the A file. Go down, post the bond. Do not leave this building without posting the bond. Good luck. Barton, Kelly Lynn Barton, 23R 513503. He's gonna need to fill out a petition for one too, for a court-appointed, Lisa. Your name, ma'am?
Kelly LeBron.
Michael A. Carmen, 37324 on behalf of the defendant.
All right, how's she going to proceed?
Your Honor, she will plead guilty, and then just I'll give an explanation of what my client indicates happened.
I'm gonna need Jessica in here. Will you call her, please? If you plead guilty here, I want you to understand this is your this would be your seventh technical violation. You could get 93 days in jail with credit for any time served. You understand that? Did you sign an advice of rights form today? You're presumed innocent. They have to prove you guilty by preponderance. You have the right to question their witnesses, to bring in your own, to use the subpoena powers to court to bring in those witnesses. You have the right at a trial to testify or remain silent, or at a hearing. If you remain silent, that silence would not be held against you. Do you understand that?
Yes, sir.
If you plead guilty, you're giving up all those rights, and we're not going to have a trial. Do you understand that?
Yes, sir.
The charge that you fail to refrain from consuming alcohol or drugs, testing positive for amphetamines on a chemical test on May 19 of 25. How do you plead? I'm sorry? Did you consume amphetamines?
Not knowingly, no.
Did you consume amphetamines?
I took my daughter's medication by accident. I did not know I consumed any food except my medication, I thought.
I'm just asking you, did you consume amphetamines?
Unfortunately, yes. Like the worst day ever.
You're not gonna tell me you didn't knowingly consume amphetamines, are you?
Yeah, I did. I had no idea about it. I'm bipolar. She has ADHD. We don't keep.
How old is she?
She's gonna be 14 next month.
Where does she keep her medication in?
She usually keeps them in the bathroom. She was packing to go to her friend's house for Comic-Con that weekend, so she brought everything in the bedroom.
What did you think you were taking?
I thought I was taking my Paxil.
What were the other drugs she's been using? Wasn't some of these, I don't know, I'm gonna check. My
Positive for amphetamines in the past and methamphetamines. She
Yeah, I mean, I don't
tested
know.
positive for alcohol.
Anybody forced you to plead guilty?
No.
You consume those, you consume those intentionally though, correct? I understand you're trying to tell me, hang on, please. Hang on, please. You consumed drugs. I know you're telling me that you thought they were your daughters, right?
No, I thought they were mine.
I'm sorry, you thought they were yours.
I have anxiety, sir. I
Ma'am.
don't take anything like that. I have a very, very bad anxiety. I don't take anything like that. It would be the worst thing I could take. I went to work that day. I didn't know what I had taken.
All right. Has anybody forced you to plead guilty?
No.
How many times has she pled guilty to consuming meth or amphetamines?
Including this time, I would say this is the third time.
So what were the other two?
Well, let's see, she pled guilty on April 1st for amphetamines. She pled guilty on June 10th of 2024 for amphetamines. She pled guilty July of 24 for amphetamines. September 12th of 24, she pled guilty for alcohol. Alcohol again in November of 24, and then alcohol in the most recent one, which was March 13th of 25, Your Honor.
I have a problem with alcohol. I don't-
We got a problem with other drugs too.
No, I don't do drugs. I never have been a drug addict.
Did I mishear you? Say that again, anything relating to the drugs.
We have tested positive for violations for amphetamines on April 1st of 24, June 10th of 24, July 16th of 24, and then the most recent one, Your Honor. So that's 4 times, I believe.
I can't remember what happened in those.
Wait a minute. Did you accidentally take the amphetamines on those days?
I do vaguely recall an excuse on one of her other violations regarding taking something she didn't believe was that. I can't recall specifically if that was it, but it does sound like a familiar story I've heard before from a violation with Kelly in the past.
All right. At a minimum, you're responsible for not ingesting or consuming something that you cannot consume. Okay? That you're ordered not to consume.
I haven't been taking any medications at all because
Ma'am.
this can't happen.
Ma'am. Then why'd you take that medication?
I put that
Ma'am,
as time was on my medication.
ma'am, you keep interrupting.
I'm sorry.
You said you haven't been taking any medications. When's the last time you took a medication then, other than accidentally taking this amphetamine back on May the 19th?
I just stopped taking my medication last month.
Well, that's subsequent to May 19th, right?
No.
It's after May 19th, right? May 19th was 2 months ago.
Yeah, I stopped taking it last month because.
I know, so that was after you tested on this one.
Yeah,
After you
so
took,
that way it wouldn't happen again. I can't have that happening.
what do you go up to just pill bottles and start taking
No.
them? I mean, come on. I've heard enough of this.
No, I understand.
I can't get you straight. I don't know who you're kidding. I'm gonna accept the plea. You're responsible for knowing what's going inside of your body. I don't know what to do with you anymore, Ms. Barton. Mr. Kerman, what would you like to say?
I really, just that this was over 2 months ago, no subsequent violation allegations since then. I think she has been making a concerted effort. With a bipolar condition, I believe, how medication affects that, I think is definitely a factor here.
I'm shocked. I've only sent her to, am I right that I've only sent her to jail once for 3 days?
You sent her to jail twice, once for 3 days and then the other time for 3 days.
Any thoughts?
I
feel like we've gone around and around with Kelly. She'll do well for a while and then we have some issues again. Since the warrant was called, she wasn't warrant status. She did continue testing. She's tested June 4th negative, June 16th she was negative, July 7th she was negative. She's set to be discharged September 7th of this year, Your Honor. Only thing left for her is the money. Everything else she's done that was ordered, community service, court work program, she's completed.
How much does she
substance
owe?
abuse, $240, I believe, when I looked this morning, unless she's paid since then.
I don't get paid this weekend.
You what?
240.
I get paid this weekend.
We haven't done too well for you. Either that or you haven't tried hard enough, maybe a combination thereof. I mean, come on. I don't understand why you're looking me in the eye and telling me these things. I mean, please. I'm gonna go a lot easier when people are honest with me. I don't like people lying to me. This is not, you're not pulling one over me. You can insist you accidentally took this. You didn't accidentally take this. You didn't. I don't know why you stand there and tell me this. I mean, I feel sorry for you. You got an addiction. I guess we should have got her in this. Did we try to get her in the sobriety court or anything?
I don't believe so, Your Honor.
Yeah, it's our fault. Can I see the screening?
Yes, Your Honor.
I mean, you seem like a very nice lady. Yeah, I mean, there were just not enough red flags at the time, but it's become apparent over time that she's got a serious problem. She scored a category 2 on the alcohol and 3 on the drug use. It's not exactly like this was screaming sobriety court. No, she had no established criminal history. She had a .172 on the breathalyzer, blood draw.
Judge, and she was ordered the alcohol education class originally. After her violations, you did order her to then do IOP. So she didn't even score high enough originally for treatment. It was later that you amended it for treatment.
Your Honor, in lieu of jail, would you consider ordering further treatment? You push out probation a little bit, see how she does?
We can't, I don't think. When did I place her on probation? Oh, February 24. Did you attend treatment? Where are we with that?
She completed treatment, Your Honor.
I believe the balance is 280 now.
I show a balance of
Of the
240, Judge.
proposed,
Okay, maybe there's another payment that isn't reflected on the ROA. Because you can't pay that today, right?
I get paid this weekend. I can pay it Monday, Tuesday.
I don't know what else to tell you. I'm not gonna have probation keep chasing you. I'm gonna keep you on probation. I'm not extending probation. You're to serve 7 days or 10 days jail forthwith. Good luck. Have a seat, ma'am. I've tried everything I can with you. You're not helping us help you. There's nothing I can do anymore. I'm sorry. Good luck. Wayne, Mike, Mr. Rogers, get your lawyer in here, please. People against, Wilson, Quinton, Lamar Wilson Jr., 2B, 141924A and B. Your name, sir?
Quentin Wilson, Jr.
Give me 1 second until your lawyer comes in, will you please?
State of Texas, anything further to present for evidence?
No, sir.
And does the state finally rest?
Yes, sir, we do.
Defense, anything further to present for evidence in this case?
Yes, sir.
And does the defense finally rest?
Yes, sir.
Ladies and gentlemen of the jury, the parties have rested, and at this time, I'm going to read to you the jury charge, which contains all of the law necessary for your deliberations. In continuing to discharge your responsibilities as jurors, please continue to observe the instructions previously given to you. These instructions are given to you because your conduct is subject to review, the same as that of witnesses, parties, attorneys, and myself. Please listen carefully, as I know you will, as I read this charge to you. It will be left with you when you go to deliberate to refer to as necessary. Members of the jury, the defendant stands charged by indictment with the offense of murder, alleged to have been committed in Jefferson County, Texas, on or about August 6, 2023. The defendant has entered a plea of not guilty to this indictment. Our law requires that I submit the following charge to you in this case. This charge contains all of the law necessary to enable you to reach a verdict or verdicts. If any evidence was presented to raise an issue, the law on that issue must be provided. Definitions, so that you can better understand some of the words and terms used in the charge, the law provides the following definitions. Murder. A person commits the offense of murder if he intentionally or knowingly causes the death of an individual. Intentionally. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. Knowingly. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Deadly weapon. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury. Or 2, anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Bodily injury simply means physical pain, illness, or any impairment of physical condition. Firearm. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using energy generated by an explosion or burning substance, or any device readily convertible to that use. Voluntary intoxication. Voluntary intoxication does not constitute a defense to the commission of a crime. We have two important, all these instructions are important, but there are 2 issues that are of main importance that the jury is going to be deliberating on. And these are going to be, I will help you with instructions on self-defense involving deadly force to protect another against deadly force by another. And the second is in self-defense from multiple assailants. As to an instruction on self-defense involving deadly force to protect against deadly force by another. If you all agree the state has proved beyond a reasonable doubt that each of the murder elements listed in these instructions have been proven, you must next consider whether the defendant's use of force was made in self-defense. You have heard evidence that when the defendant shot Ramon Whittington with a firearm, he believed his use of force was necessary to defend himself against Ramon Whittington's use or attempted use of unlawful deadly force. A person's use of deadly force against another that would otherwise constitute the crime of murder is not a criminal offense when the person reasonably believed the degree of force used was immediately necessary to protect the person against the other's use or attempted use of unlawful deadly force. Self-defense does not cover conduct in response to verbal provocation alone. The defendant must have reasonably believed that the other person had done more than verbally provoke the defendant. The defendant is not required to prove self-defense. Rather, the state must prove beyond a reasonable doubt that self-defense does not apply to the defendant's conduct. Definitions concerning the issue on self-defense. Reasonable belief. Reasonable belief means a belief that an ordinary and prudent person would have held in the same circumstances as the defendant. Deadly force means force that is intended, known by the person using it to cause death or serious bodily injury, or force that in the manner of its use or intended use is incapable of causing death or serious bodily injury. Failure to retreat. A person who has a right to be present at a location where the person uses deadly force against another is not required to retreat before using deadly force in self-defense if both of these two elements apply. One, the person with the right to be present did not provoke the person against whom the deadly force is used. And two, the person is not engaged in criminal activity at the time the deadly force is used. That is, the person using the force is not engaged in criminal activity at the time the deadly force is used. Those two have to conjunctively be working for this defendant not to be required to retreat. Therefore, in deciding whether the state has proved that the defendant did not reasonably believe his use of deadly force was necessary, you must not consider any failure of the defendant to retreat that might be shown by the evidence if you find both: one, the defendant did not provoke Ramon Whittington, the person against whom the deadly force was used by the defendant, and two, the defendant was not engaged in criminal activity at the time he used the deadly force. If you do not find both 1 and 2, you may consider any failure of the defendant to retreat that might be shown by the evidence in deciding whether the defendant reasonably believed his use of deadly force was necessary. Unlawfully carrying weapon. A person commits a Class A misdemeanor offense if he intentionally or knowingly carries on or about his person a handgun while the person is intoxicated. A handgun means any firearm that is designed, made, or adapted to be fired with one hand. Intoxication means that the defendant does not have the normal use of his mental or physical faculties by reason of the voluntary introduction of any substance into his body. Application of the law to the facts as to self-defense. If you have found that the state has proved the offense beyond a reasonable doubt, you must decide next whether the state has proved that the defendant's conduct was not justified by self-defense. To decide the issue of self-defense, you must determine whether the state has proved beyond a reasonable doubt one of the following two elements. The elements are that: one, the defendant did not believe his conduct was immediately necessary to protect himself against Ramon Whittington's use or attempted use of unlawful deadly force. or two, that the defendant's belief was not reasonable. You must all agree that the state has proved beyond a reasonable doubt either elements 1 or 2 listed in this instruction. You need not agree on which of these elements the state has proved. So if you find that the state has failed to prove beyond a reasonable doubt either element 1 or 2 listed within this jury charge application of law and facts as to self-defense, you then must find the defendant not guilty. But if you all agree the state has proved beyond a reasonable doubt each of the elements of the offense of murder, and you all agree the state has proved beyond a reasonable doubt either element 1 or 2 listed above in this application of law to the facts as self-defense, then you must find the defendant guilty. Self-defense charge. Therefore, even if you believe from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof that the defendant Jeremy Akeem Dixon used deadly force as alleged in the indictment, but that on such occasion, the defendant reasonably believed this use of deadly force was immediately necessary to protect himself against the victim's actual or apparent use or attempted use of unlawful deadly force, and 1, a reasonable person in the defendant's situation would not have retreated, and 2, that the defendant reasonably believed that the use and degree of deadly force he used was immediately necessary to protect himself against the victim's actual or apparent use or attempted use of unlawful deadly force, then you should find the defendant not guilty. However, if you believe from the evidence beyond a reasonable doubt that at the time and place in question, the defendant either 1, did not reasonably believe that the victim was actually or apparently using or attempting to use deadly force against him, or 2, that a reasonable person in the defendant's situation would have retreated, then you must find against the defendant on this plea of justification alleging self-defense. Now, we have another issue that you will be determining, and I will give you the instruction on self-defense from multiple assailants, meaning more than one person. A defendant is also entitled to a charge on the right of self-defense against multiple assailants if there is evidence received from the accused's standpoint that he was in danger of an unlawful attack or threatened attack at the hands of more than one assailant. When the proof at trial is clear that an attack is being conducted by multiple people as a group, 2 or more, a defendant is justified in using force against any member of the group, even if the recipient of that force is not engaging in conduct that would alone justify the use of force or deadly force. Now, the proof must show more evidence than simply that the person other than the actual attacker were present, that persons other than the actual attacker were present. The evidence must tend to show that the other or others joined the attack or at least were present pursuant to an agreement to do so. There must be some evidence to suggest that it was reasonable for the defendant to think that another or others than Ramon Whittington were about to attack defendant with deadly force when he used deadly force to kill Ramon Whittington. Application of the law to facts on self-defense as to multiple assailants. Therefore, as to the issue of self-defense as to multiple assailants, the jury must determine whether the state has proved beyond a reasonable doubt that either 1, the defendant did not believe his conduct was immediately necessary to protect himself against A, Ramon Whittington's use or attempted use of unlawful force, or B, Gregory Carrington's use or attempted use of unlawful force, if Ramon Whittington and Gregory Carrington were both present and acting together to attack the defendant. Or 2, that the defendant's belief was not reasonable. Therefore, if the jury believes the defendant reasonably believed that shooting Ramon Whittington was immediately necessary to protect himself against the use of deadly force, by Ramon Whittington or Gregory Carrington acting together to attack the defendant, then you should acquit the defendant of murder. Defendant's statement to police. The defendant made statements to police unless the jury believes a reasonable doubt that the defendant's statements to police that were admitted in evidence in this case was voluntarily made. Unless you believe it was voluntarily made, the jury shall not consider any statement for any purpose. Charge. Now, considering and applying all the instructions provided to you in this case, including those regarding the law of self-defense and as to multiple assailants, if you believe from the evidence beyond a reasonable doubt that in Jefferson County, Texas, on or about August 6, 2023, the defendant Jeremy Akeem Dixon did then and there intentionally or knowingly cause the death of an individual, namely Ramon Whittington, by shooting the victim in the body with a firearm, you shall find the defendant guilty of the offense of murder. Unless you so find, or if you have a reasonable doubt thereof, you shall find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt, after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You are the exclusive judges of the facts proven, the believability of the witnesses, and the way to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. You have a right to consider all of the facts that are shown by the evidence and to draw reasonable and natural inference. You cannot question the bailiff concerning his presence. If any question about the law develops during your deliberations, it must be reduced to writing and signed by your foreperson and given to the bailiff. That question will be then answered by the court as soon as possible to the extent allowed by the law. There have been a lot of exhibits. These physical exhibits, which are admitted in evidence, will be furnished to you by the bailiff if you request, and upon your request during your deliberations if necessary. After the attorneys present their final arguments to you, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during your evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict, which is attached to this charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case in accordance with the law and the evidence. Okay, we have two options here. And based upon the compilation of the instructions in this jury charge, they all apply here in focusing down to these two options. One, we, the jury, find the defendant guilty of the offense of murder as charged in the indictment, a place for the foreperson to sign. And the other, we, the jury, find the defendant not guilty of the offense of murder as charged in the indictment, with a place for the foreperson to sign. Under the rules of evidence and the Code of Criminal Procedure, the state of Texas may open and close final arguments. What says the state?
We will reserve our time for Final close, Judge, we'll bring it open.
Okay, then, Mr. Vasquez, on behalf of the defense, you may go forward. The law states that attorneys have a reasonable amount of time, and I will alert them if they get to 30 minutes. Go ahead.
Thank you, Honor. Mr. Dixon, that card, Mr. Laird. Hello. I've never set out to commit a murder, but what you've seen, I don't think is the way you go about doing it. At home with your kids, they've eaten their pizza, they're in bed, you're asleep, you get a call from your niece, car trouble. You go help her out, find out what it is, get the car towed or pushed. Go riding around looking for something to eat. Run into a guy you know that needs a ride home. His nephew or his brother or someone's left him stranded. You take him home. You're back at the scene. Walking around. Talking to people. Mr. Eckhart showed the video yesterday making a big thing out about who Mr. Dixon and this other fellow he was with, who we don't know, looking around and talking with each other and staring out in the parking lot. There were dozens of people out there walking around, talking to each other, looking in different directions. Nothing he did there was unique. They're all out there at 4 o'clock in the morning because they're young people and that's their lifestyle. No one knows what started all this. We think we know. We think it was over a woman. It could have been over something else or a slight. We just know it ended terribly. And I appreciated the state's witness, Miss Thomas and Jordan Whittington. They said they didn't know what was wrong with Ramon that night. Didn't know why he was being dismissive or not getting along or not engaging with Mr. Dixon. But pretty soon a fight erupts. And I didn't realize till yesterday, watching it, that with the enhancement and the brightening, that Mr. Dixon fought back a little better than I thought he did. He got a few blows in. I didn't realize that till yesterday, which is when Jordan jumped in, the guy with no shirt, and they are beating him on the ground. And if you need to watch it again, I know you will if you need to. And they were kicking him on the ground. Ramon's timber or whatever those boots were, those light colored boots, he was being kicked in the head. You don't see it real clearly. It's next to Crystal Thomas's car. I couldn't believe his medical workers weren't worse. He had a broken nose and a through leg, a shot through and through in the leg. I thought he'd look much worse. But at least 3 or 4 hours later, he didn't look. I thought he'd look worse. That ebbs down, it calms down for some reason. We don't know what they're saying. We can interpret their body language. But not long after that, Mr. Carrington shows up. Mr. Carrington shows up with this exhibit, number 153. This exhibit right here with this extender holding, I think, 30 shots. Evidence shows he turned it over to someone. Apparently that's how it goes. You got the weapon, you turn it over, you're gonna fight for a while, someone holds it for you, you get it back later. So then it's Carrington, Ramond, and Jordan on him. That's the second fight. That one's a little obscure. There's an SUV that makes it hard to see the fight. You see the wailing in the arms and the hands, but you don't, or I couldn't see Mr. Dixon down on the ground again. That's the same weapon that Mr. Carrington pointed at Mr. Dixon's head about 5 minutes later. when that second fight calmed down, they're in that man's yard. It's off camera. It's in between what you've seen on camera 4 and in the alley on camera 16. He's in that yard with, I think, 4 people, maybe more. Ramon's in that yard. Chucky, who y'all have heard that name a lot, he's in that yard. Gregory Carrington's in that yard. And a big guy, maybe Mr. Prince, or maybe just a big fella that was unidentified, is in that yard. Mr. Dixon has Chucky pinned down, and Carrington puts that gun to his head and says, "Let him go." At this time, he's already missing his keys. He thinks he's missing his keys. His testimony is he's missing his keys. His pants are down when he's in that man's yard before the man comes out and tells them all to get out of there before he shoots them. And he loses his wallet, and he loses his phone. He doesn't lose his pistol. I don't know whether he had his keys on him then or not. The police found those keys in his car, lying on the car driver's side seat. Who does that? Who leaves an unlocked car with their keys on a driver's side seat? Whoever put those keys there is the person that has his weapon. I have no evidence of that. That's me playing amateur detective. But whether or not he has his keys or not, has a gun to his head in that fella's yard. And then we're on camera 16 that you see ends up with the shooting. There's evidence, and it's in the charge about intoxication. Mr. Dixon never says he was intoxicated. He says he was impaired. He says he was drinking. And I think he says drunk at one time when being questioned by the state. We do know a lot of drinking was going on out there. A lot of youth, a lot of drinking, a lot of people, a lot of guns. That's a bad combination. I don't know how dazed he was or how intoxicated he was. He'd been kicked in the head. I don't know. I don't think that's something you recover from in 10 minutes. But he can't get his keys back, or he thinks he can't get his keys back. He can't get his possession. They tell him to take it out in blood. We fought, we want to fight some more, or we're going to shoot it out, or you're not leaving here. And they're not leaving. None of them are going to walk away from this. This charge talks about reasonable, prudent persons. I look down on no one. I criticize no one's lifestyle. But not everyone is a reasonable, prudent person like the Father knows best. These are wild, young men and women. If you retreat, you walk away from something like that, you're a weenie, you're shunned, you're a coward. I know it makes no sense, it's all bravado, but they're not us. They are not us. They're out there at 4 in the morning. Armed, a lot of them heavily armed. He didn't shoot Ramon for fun. And I know Mr. Dixon wishes he'd stayed home that night. He shot Ramon because he's fearful of his life for Ramon and Gregory Carrington, who'd held him at gunpoint. The state has to prove to you beyond a reasonable doubt that Mr. Dixon's actions were not in self-defense. If you can't decide that, when you deliberate, that's reasonable doubt. 12 of you, 12 different verdicts. 12 different people who watched all this. And if any of you can't decide this after deliberation, after a lot of deliberation, if you can't come up with a unanimous decision, and the judge will tell you, keep deliberating, exhaust all channels. After all that, if you can't decide, you haven't wasted your time. You've still engaged and obligated your jury service. I only say this because I've had people come up to me later and go, well, we just, they weren't going to budge, so we just, they were hard-headed, and I'm just tired of it. I want to get out of there. What would the case scenario been? Mr. Dixon, I think, is like a 33-year-old man. I wonder what would have happened, or what the charge would have been if he's not 33. He was 63 or 68. He acted in self-defense from an assailant or two assailants, and I urge you to find him not guilty. And thank all of you for being here and hanging here with us through all this.
State Texan.
Morning, everyone. Thank you for being here. I'm really sorry that that it spilled over into another week. Not that that was anything that had to do with us, but but just that it's, I think on behalf of all of us, that wasn't our hope. And obviously, sometimes these cases do spill over, and sometimes, the defendant takes the stand, and sometimes the defendant takes the stand and he lies, and we have to go and kind of, comb through that and look and see what inconsistencies or what things are true and not true from that testimony, and if we're able to try and present you some evidence to show that he was wrong with his lines. So we've got a lot to talk about. We got a lot to cover. I am going to walk you through the self-defense instructions that the court has given you, just so you can kind of understand what you're dealing with here. Because really, in jury selection, we talked a lot about really just I asked you to mostly focus on two things: whether he actually believed that it was immediately necessary to use deadly force to protect himself from someone else's unlawful or use or attempted use of unlawful deadly force, and then two is whether that belief was reasonable. Well, there's a lot of other small moving parts to self-defense. But unfortunately, in these kind of situations, a lot of times the issue does have to be raised. And you never really know from our perspective, because we don't get discovery from the defense. We have no idea what they're going to do, or if they're going to call witnesses or anything like that. So a lot of times it's a guessing game, and sometimes we're able to guess pretty accurately. But it always does depend on what evidence is ultimately raised. And in this case, they are raising this issue of this other threat, Gregory Carrington, and that being the reason that they're contending he was justified in killing Raymond Whittington. So there's a few other things that come into play, but what you'll notice is that they all kind of come back to those two core issues. So focusing on those throughout the trial and just whether or not this makes sense, whether or not it adds up, whether it's reasonable, that'll always ultimately get you to the kind of in the sphere of the right answer. Because I think the way I look at self-defense from a more I guess big picture perspective is I think that a lot of times it really does. You can you look and see whether it passes the eye test. And a lot of the law and the instructions that you get more or less are attempting to reflect that in one way or another. And so let me show you what I'm talking about. So this is what your charge looks like, okay? There's one page and, you know, it's got instructions and usually the way Judge Stevens does these charges is there's going to be one definition or one topic per page. So one page is going to address one issue or one application of that issue. And then the next page or the next group of pages are going to address the next thing that you'll need to understand. And so if we go, you'll see that it's got just very simple outline of instructions, and it gives you definitions for an offense like murder. And obviously, I mean, I can blow these up for you, but you're going to have these. And ultimately, you're going to have to pick a foreman. What I suggest, especially in a case like this, where you may want to refer to the charge several times while you're talking, just to make sure that what y'all are talking about is correctly applying the law. I always suggest pick a foreman that is willing to make sure to kind of keep the group on task with what it says in that charge. Make sure that we're looking and reading this and then discussing whatever y'all think is pertinent about that. So we keep going. You got definitions like intentionally, knowingly, deadly weapon. That's in our indictment. Firearm is a deadly weapon. Obviously, we see in the video he shoots firearms. So I mean, some of these things are very simple, not going to be that controversial at all. Okay, so here's one that we haven't really talked too much about because it's kind of it's pretty simple definition, and what you'll see how it's actually used in another definition, which is used in another definition, and ultimately kind of helps get to like what deadly force is. That's ultimately what all this is about, right? So just kind of be thinking ahead of time about distinguishing what bodily injury is versus serious bodily injury, because there's a big difference between those two. And serious bodily injury or death are what is the prerequisite for deadly force. Remember, we talked during jury selection about, well, there's more of a general self-defense statute that just talks about use of unlawful or use of force to protect yourself against someone else's unlawful use of force. But what we're dealing with in this case is actually that plus the next statute right after that, which is deadly force to protect against someone else's unlawful deadly force. You can only use deadly force, meaning he can only shoot Raymond Whittington if he was under threat from someone else's unlawful deadly force. So, and then here's our definition for serious bodily injury, and I'm gonna get into these a little bit more and kind of talk to you about, what evidence I think is maybe helpful for you on these types of issues, but I just want you to kind of see what you're looking at here. And you'll notice that it says means bodily injury, and then it goes and expands further. So it's incorporating that definition from bodily injury that we just went into. So that's why they kind of build on each other, right? Firearm, that's another definition that was going to be pretty obvious. And then here we get to our self-defense instructions. So this is the first one. I will tell you that based on everything they've argued, this one really doesn't apply at all. Because what this involves is it's giving you a lot of the general instructions about self-defense involving deadly force to protect against deadly force by another. But it's not the multiple assailants. So the ultimate issue for this particular application is whether the person who deadly force was used against, meaning Raymond Whittington, Pooh, whether that person was using or attempting to use unlawful deadly force. I think everybody at this point is in agreement that at the time Jeremy Dixon shot Raymond Whittington, that Raymond Whittington didn't have a gun, wasn't attempting to use unlawful deadly force. He might have been trying to use force, but not unlawful deadly force. So the issue then becomes what Jeremy Dixon testified about. He is talking about Greg Carrington from coming behind Pooh and his belief that Greg Carrington had a gun. That's what this is coming down to, really. But this instruction right here is still very important because it's going to give you a lot of the information that you need for your next instructions. It's also going to give you the information about what reasonable belief is and things like that. So you still got definitions and things like that that you would be applying. And it also reminds you that it is our burden to prove one of the two things. And what I mean by that is this is application of law and facts to self-defense. It says to decide the issue of self-defense, you must determine whether the state has proved beyond a reasonable doubt one of the two following elements. So why do we only technically have to prove one? I think both are proven here. But why do we only have to prove one? Because in order for the killing of Raymond Whittington to be justified, it has to be Jeremy Dixon had to have believed his conduct was immediately necessary to protect himself against Raymond Whittington's use or attempted use of unlawful deadly force, or with the multiple assailant, which we'll talk about, Gregory Carrington. And for it to be justified, that belief has to be reasonable. So if either one of those, if we prove to you that it was not reasonable or that he didn't actually believe that, then it's not self-defense. The other thing that this instruction is important information that it provides you, you don't have to agree on which one it is. You might say, I just don't believe what he did was reasonable. I don't believe that he thought that belief that he had, that was reasonable. I don't think an ordinary prudent person would believe that he was in fear for his life, like Jeremy Dixon claims. Whereas you might believe, I don't think he thought that at all. I think he was lying about the whole thing. Or I think that he thought something totally different. Or like Dorian Price said on the stand, I think he was mad. He was mad about what happened over in the side yard. So if you both agree that one of those elements is established, that we've proven one of those elements, then it's not self-defense. Because in order for it to be justified, both have to be true, meaning I didn't prove either one. Also, we have deadly force, which I'll get into that definition in a minute, but here's the next one that I want to point out to you. Failure to retreat. That's not something that we talked a lot about during jury selection, but it's one of those, like what I was talking about earlier. It's kind of it's part of that eye test rule, and you know it when you see it. Failure to retreat, what these instructions explain is that if someone is in a situation where they are faced with having to use deadly force or believe they are faced with using deadly force, it becomes incumbent on them to try and get themselves out of this situation. And there's only a certain set of facts or certain circumstance where they don't have to retreat before their deadly force would be justified being used. And what the law says is that there's actually a couple of very easy ways to determine whether or not someone failed to retreat. One, if they had the right to be present at that location, maybe they weren't trespassing or something like that, and they did not provoke the other person, meaning the person that they killed, Raymond Whittington, they didn't provoke that person. That's why we spent a lot of time looking at the earlier fight. Because believe it or not, I mean, obviously the earlier fight is all part of that night, but there's no deadly force used in that earlier fight. There's nothing to support self-defense from that earlier fight. It really all comes down to what he says he believed in that alley in the second altercation. But whether or not that earlier fight, whether or not we are able to determine from that Jeremy Dixon did anything to provoke Raymond Whittington. And then the other part, that the person is not engaged in criminal activity at the time deadly force is used. Which is why if you find that he did not provoke Raymond Whittington, and you find that he was not engaged in criminal activity, then you don't consider whether he failed to retreat. But if there's evidence, if we show you beyond a reasonable doubt that he did provoke, or that he was engaged in criminal activity, if one of those is true beyond a reasonable doubt, then you consider whether he failed to retreat as part of whether or not his belief was reasonable. That's what it applies to. It helps inform you on that second prong of our test, whether it was reasonable. And that's where this comes in. Unlawful carrying of a weapon. You notice I asked the detective about that right at the end yesterday. Because carrying a handgun while intoxicated is a crime, Class A misdemeanor. And it makes sense, because why would that be a crime? Oh yeah, to prevent situations like this from happening. Now, here is the real crux of their self-defense argument is, I'm sorry, we just looked at this one. It's this right here. So you've got this application paragraph, and then you have a self-defense charge, which also is informative and kind of restates so that you understand exactly what you're needing to be considering. Then you get to this next instruction, which is multiple assailants. And ultimately, I think this paragraph right here is helpful to kind of give you the basic rule of law. Is that when the proof at trial is clear that an attack being conducted by multiple people as a group, the defendant is justified in using force against any member of the group, even if the recipient of that force is not engaged in conduct that would alone justify the use of force or deadly force. So what does that mean? Well, it means that there could, if there were multiple assailants and they were conducting an attack as a group, that if one of those had a reasonable threat of deadly force to Jeremy Dixon, that he could potentially use deadly force in self-defense against anyone in that group. Now we'll look at this closer and we'll kind of take a look at why this is not true in this case. But you get to the application paragraph for or application instruction for self-defense as to multiple assailants, and you'll see that it's kind of similarly situated as the previous application instruction that we just went over. And you'll see that we're still considering the same things, just a little bit different. And so I highlighted the one that's different for you, and it's 1B. So 1, that's the same element prong that we are considering in any self-defense inquiry. Defendant did not believe that his conduct was immediately necessary to protect himself. We have to prove that to you. Either that, or we have to prove that his belief was not reason. And then 1A, that's a really more or less a restatement of the previous self-defense instruction, because it's talking about Raymond Whittington's use of unlawful deadly force as being the threat. But B is what describes the multiple assailant aspect of this instruction. Right? Immediately necessary to protect himself against B, Gregory Carrington's use or attempted use of unlawful deadly force. I may have a wrong version of that. It should say deadly there, I think.
It's use or deadly force, use of force or deadly force, as the case may be.
I see, okay. And the previous instruction paragraph for that actually says that exactly. So I mean, it's obviously it's very clear that this deadly force can only be used when faced with the use or attempted use of unlawful deadly force. There is no exception to that or situation where it can be some other type of force. It has to be unlawful deadly force. But what you'll see is that it has that second part there to that. If Raymond Whittington and Gregory Carrington were both present and acting together to attack the defendant. That's the difference. That's the difference between self-defense from a threat of unlawful deadly force from Raymond Whittington and self-defense from a threat of unlawful deadly force from a group of people, any individual of that group threatening with deadly force. Okay. And that belief still has to be reasonable. And then this is just your final charge. If you're answering that we have proven to you at least one of those elements of self-defense, meaning that he did not actually believe that it was immediately necessary to use deadly force, being Jeremy did not believe that, or that that belief wasn't reasonable. If we've proven one of those to you, then you would find him guilty of murder. Okay, what I want to talk to you about is looking at some of the things he said. Because at the end of the day, a lot of this comes down to what he testified to, what he said at the hospital. He's the one who's saying that he was in fear of his life. Okay, so as we kind of talked about this, let's just go through the timeline of that night. So according to Jeremy, 2 a.m. he gets this call, and he goes to help out a friend. I don't know that I believe anything he says, to be honest. But there are some things that we can verify, and we know either they happened in the video or that there's some other way to independently kind of corroborate that. But he says he goes to help his niece. Well, the witness that testified for him yesterday said he called him or texted him 7 different times wanting him to come out that night. Well, Jeremy says he had no intentions of going out that night. He was looking for food. Again, both these things, a lot of the things that he said don't really jive together. But regardless, we get closer to 3 a.m. and that's when the video begins at the S&S grocery. By this point, Jeremy has explained that he has finished with what he was doing over with his niece and was headed over towards the B&B shack across the road. And after they had their parking lot full, he goes over to S&S grocery. Ends up at S&S grocery sometime around 3:30. 3:55 a.m. That's the first time we see him on the video in State's Exhibit 1. All right, now I'm going to show you all this and just explain to you one thing. I know it feels like everything I've been doing is very tedious. My goal in these types of cases, especially where there's something that you've really got to look closely at on the video, or something that you've got to see clearly and closely. I try to show it to you as many times as possible so you're sick of seeing it. Because ultimately, it's easier for us to all look at it together out here. And you feel like you've seen it enough where you don't necessarily even need to see it anymore back there. But if you do want to see it back there, I just want to show you what the exhibit looks like so you know how to navigate what we're going through. Just remind you. So you've got camera A16. That's the alleyway camera, right? That's where we see the shooter. You got camera A4. That's the front parking lot. Okay, so when we go into those, y'all remember I keep saying when I'm playing one of the videos, I'm playing the last file in that folder. And the reason I say that is so we make a clear record of what exactly where everything is. That file right there. The big one. As far as the size. That's the one that captures the fight in the front parking lot. That's the one that captures Jeremy Dixon walking up at 3:55 a.m. It captures everything all the way to the point that they're going off to the right and going into the other camera. And then if we go back into the folder for camera A16, we go all the way down to the bottom, the file ending in 1054. The very last one. That's the one that captures Raymond and Jeremy Dixon walking across towards Concord Road, and then a few minutes later, coming back and all the way up to the point that he shoots and kills Raymond. Okay. So we're about 358 right there. And we've already seen Jeremy Dixon for a few minutes. He's over there. So 3:55, he shows up. 4:02 a.m., he's walking across that parking lot. By 4:03, he and Raymond are already arguing. As we watched yesterday and we saw that kind of interaction with them at first, where Jeremy seems to be antagonizing him at first. And then Raymond, I don't know how to describe it. It's like he was kind of cowering away. Like he didn't want to have this interaction at all. And he didn't want to be around him. It's unusual. And we'll look at it here again in just a second. But very quickly, Raymond, his posture changes, his demeanor changes. No doubt, when it comes to the fight, Raymond was in the wrong. So was his brother. And you know what? Technically, so was Trent. But that's not why this is relevant. Why this is relevant is because we're trying to decide whether 15, 20 minutes later, Jeremy Dixon believed that it was immediately necessary for him to kill Raymond Bennington in self-defense, and whether that belief was reasonable. Well, part of the reasonableness inquiry that we make is whether or not he failed to retreat, meaning whether or not he could have left. That makes this very important. Because one of the things that we look at and one of the things we ask, and when we're looking at whether someone could have left and should have left, is whether or not they provoked. And that's what we see here. We see Jeremy Dixon going out there and provoke. We see multiple times where he could have easily left, but he didn't. And he claims that they had my keys. Chucky stole my keys. No. We don't even know if his car was unlocked. He may have locked his keys in his car. We don't know. There was blood on the handle. And so they didn't try and open it. Now we know that's Jeremy Dixon's blood based on everything we saw from the layout of the shell casings and all of that. But he did say that he went to his car. And he did say that he couldn't get in. And then lo and behold, he's claiming on the call yesterday we listened to that, well, who had my keys with the blue hook in my pocket, in the pocket. I was trying to get them back. They promised me they were going to give them back, and then they did. Either he's wrong and just making something up, or he's outright lying. Neither one of those bodes very well for him on this issue, right?
What, anything?
Well, Your Honor, my client is asking for time served. He's been incarcerated since February 2025.
Shocking. Go ahead.
There's just nothing else to add, Your Honor. He's looking forward to completing his debt to society and getting released. He's got positive plans for his life, Your Honor. He does not plan to be before this court again.
What have you been incarcerated since February for, sir?
I was dealing with a case from Flat Rock and a case out of Wayne County.
Mr. Griggs, was that a retail fraud charge?
No, that was the first one from Wayne County was a GTA case that was dismissed. But I served 90 days on that. They gave me time served.
I'm just gonna give you credit for time served. 100 fines, 200 costs, 75 victims' rights, $50 justice assessment, 4 1/4, 6 days, credit 6. You're all set. We'll close the case. Good luck. Thank you.
Thank you, Your Honor.
People against Johnson, Dwayne Johnson. Dwayne Montiel, Alec Johnson, 25W838974. A, B, and C, your name.
Good morning, Your Honor. Michael Crawford. Good afternoon, Your Honor. Michael Crawford representing Mr. Johnson.
Dwayne Johnson.
Is he seeing you? Wait, formal reading?
Yes, Your Honor.
He's now going to plead to allowing an unlicensed driver to drive with the suspend to be dismissed. He's going to plead responsible to impeding traffic on the speeding, and then the other charge, the no insurance, would be dismissed. True?
Yes, Your Honor.
Is that what you want to do? Sir?
I'm gonna plead responsible to impeding.
Is that what you want to do? Yes or no?
Yes,
And you're also going to plead guilty to allowing an unlicensed driver to drive, right?
yes,
If you plead to that charge, allowing an unlicensed driver to drive, the possible penalties are up to 500 fines, 90 days jail costs, or all those. If you plead on the impeding, that'll be 0 points. If you plead to that, I'm going to dismiss the suspend, speed, and no insurance. You understand that and agree to that?
yes, Your Honor.
All right. Did you sign, read, and understand the advice of rights?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or trial. Do you understand that?
Yes, Your
The
Honor.
charge of allowing an unlicensed driver to drive, how do you plead?
Guilty.
On June 23 of 25, were you in control of a motor vehicle that was being operated in the city of Woodhaven, county of Wayne, on Hall near Van Horn?
Yes,
And you allowed somebody to drive that was unlicensed, and that was you, true?
yes,
Are you on probation or parole?
no,
Anybody forced you to plead guilty
no,
to the charge of impeding traffic, responsible or not responsible?
responsible.
That plea is accepted. The plea is accepted to allow an unlicensed driver to drive. The suspend, speed, and no insurance are dismissed. Anything, Mr. Crawford?
No, Your Honor. I just want the court to know my client now has a valid driver's license, and he plans on keeping the valid driver's license, Your Honor. He's working, but he doesn't make that much, Your Honor. The court could be as lenient as possible. He would appreciate that because he's gonna need a payment plan, which we'll discuss.
You gotta stop doing this, young man. Anything?
No,
100 fines, 100 costs, 75 victim strike fee, $50 justice assessment, 3 1/4 or 60 days, 175 on the impeding, 500's total. Does he have any of that today?
Your Honor, he can pay $50 today, Your Honor. What he's proposing to pay is $100 a month starting August the 11th.
Does he work? Where?
yes, Home Depot.
How much you make?
I would say about 500 a week.
Well, how come you're only gonna pay $100 a month?
I have other fines that I have to pay.
Pay 50 now, 100 per month, beginning August the 11th. You'll pay that first on the impeding, and then $100 per month after you pay the fines and costs on the impeding. You'll pay on the allowing an unlicensed driver to drive. They'll give you a printout down the hall. If you don't have the money at any time, you call the court, we'll go on Zoom, I'll give you an extension, okay?
Yes, Your Honor.
I wish you well. Time to grow up, son. Good luck. People against
Thank you.
Zanatti, Michelle Yvonne Mohammed Zanatti, 25W838192. Do we have John Davis here? John Earl Davis, 25W839-200A and B. Defendant failed to appear. Issue show cause. Give me 1 second. We're going to issue a show cause on that charge. Wait a minute, didn't I set this for August 6th? I set this for August 6th, Lisa, didn't I?
Who is that, Judge?
John Earl Davis?
Yes, yesterday when he couldn't post, I moved it to today, but I guess he posted the PD last night.
How'd you post it? Let's give him the benefit of the doubt.
I can reschedule it and send him.
Yeah, let's set for August the 6th, okay? Since I told him that. And I don't know, I gave him a personal bond. Did somebody else give him a cash bond, or did I give him a cash bond on another case?
I believe it was another case.
Okay. All right, here's what I'm gonna
It
do.
was Judge Hessen's case you put a bond on.
Michelle Yvonne Mohammed Zanatti, 25W838192. Your name, ma'am?
State your name for the record.
Oh, I'm sorry. Michelle Zanatti?
She's going to plead to allowing an unlicensed driver to drive with a suspended to be dismissed, true?
True, Your Honor.
If you do that, It's punishable by up to 500 fines, 90 days jail, costs of all those. Do you understand that?
I do,
And did you sign, read, and understand an advice of rights form?
yes,
If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
yes,
All right. You understand all your rights, correct?
I do.
All right, to the charge, allowing an unlicensed driver to drive, how do you plead?
Guilty?
Were you in control of a 2003 Dodge that was being operated on Allen or Weston Woodhaven, March 22 of 25 at 9:30 in the morning?
Yes,
Did you allow somebody to drive that was unlicensed, and was that you?
that was me.
And are you on probation or parole?
No,
Anybody from the world forced you to plead guilty?
no,
Please accept it to that charge. The suspense dismissed. Counsel, anything?
Your Honor, there was some confusion about the status of her license. She feels terrible about this. She believes she was driving legally. She's taking steps now to get herself a valid driver's license. Right now, she's on a restricted license. She's got an exam she's got to take, which she's currently scheduling now, Your Honor. So she won't be back for this type of thing.
Good enough. Anything? 100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 40 and attorney fees, 365 or 60 days. Can you pay that today?
Your Honor, my client can't pay that today. She just lost her job recently. She can pay $50 a month starting on the 1st, and she's looking for work, Your Honor.
50 per month beginning August the 1st. If you don't have the money, you call the court, we'll go on Zoom. Okay? Honor before any due date. Good luck.
my apologies.
You're all right. Carson Gincott, 24WA33195. I'm told defendant complied, but I just, I'm gonna require them to show up on these. Issue show cause for failure to appear for review hearing and why conviction should not enter for failure to do so. So we'll do that one. People Against Street, Maya Latrice Street, 25W8388853 and 25W839217. Do we have Mr. Levitt? Is he ready on his? What's going on?
Good afternoon, Your Honor. I've been having trouble catching up with the prosecutor today, so.
Yeah, he marked it as a no-show, so he's gotta go back and talk to him,
Oh, geez.
because he never was.
Hang on one second. Your appearance?
Good afternoon, Your Honor. Michael Crawford representing Miss Street Station at the register.
Maya Street.
She's gonna plead to no ops.
That's correct,
The
Your Honor.
suspend will be dismissed.
Correct.
For purposes of arraignment, she stands mute, waives formal reading.
Yes, Your Honor.
And that's when, and then the other one's gonna be dismissed, right? The other suspend?
Yes, Your Honor.
So 839-217 will be dismissed.
Correct.
Ms. Street, you need to start driving with a valid license. If you plead to no ops, the possible penalties are up to 100 fines, 90 days jail, costs are all those. I'll then dismiss the suspend on file 838853, and I'll also dismiss the suspend on 839217. That's per the agreement. You understand all that? I can't hear you.
Yes.
You just sign, read, and understand the advice of rights. You plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
All right, you understand all your rights?
Yes.
To the charge, no valid operator's license on person, how do you plead?
Guilty.
On the 27th of May at 25, were you operating a motor vehicle on Hall near Grixon Woodhaven?
Yes.
Did you have a valid license with you on your person?
No.
Are you on probation or parole?
No.
Anybody in the world force you to plead guilty?
No.
Please accept it to that charge. The suspend's dismissed on that file. Suspend's dismissed on 25W8399217. Lisa, can I ask a question? Does the prosecutor know that Mr. Levitt's in there waiting?
Yes.
Yeah, I've put him in there 3 times. I don't know what the issue is. I just put him in again.
Okay. Anything?
Your Honor, my client is working hard on getting a valid driver's license. Unfortunately, she doesn't have a lot of support in her personal life. It's been hard for her to get around. She has a friend of hers here in the courtroom who has tried to assist with some transportation, but.
Who's that?
My friend.
Yeah. We're best friends, but Your Honor, she understands that she cannot continue with this behavior. She needs to find another alternative. She's gonna find that, Your Honor. She's trying to get her money together now so she can pay everything she needs to pay. So she's working on it.
Who's there, Rila Destisha?
My mom.
She gonna let you apply the bond?
Yeah.
Okay, you gotta deal with my judicial clerk down the hall. On this one, 100 fines, 100 costs. Is there anything you want to say?
No.
75 victims' rights fee, $50 justice assessment. 3 1/4 or 60 days. I have bonds here. Police, I'm gonna have you deal with that, your mom can come in and get some of her money back. Because you have a $300 bond. Maybe only a 300. No, that's it. So she can come in, we'll apply the bond, but you need to pay the rest. You can do that, right?
Your Honor, my client can only pay 100 a month. She paid 100 on August the 13th, and I think that's the balance there.
Well, she's gonna pay 270 today, right? Your mom's gonna let you apply the bond?
Yeah.
270 now, and I'll let you pay the balance by August the 10th, okay?
Okay.
Good luck. Thank you.
Thank you, Your Honor.
Mr. Levitt, did you get a hold of him?
I did, Your Honor. He's filling out the plea sheet right now, Mr. Ulrich, and we should be all set.
John, would you go get that from me? I got it.
Mr. Crawford still has one more.
All right, Mr. Crawford, you got another one. I gotta adjourn it. I cannot.
Yeah, I'm gonna tell you.
How you doing there, Mr. Levitt? Everything good?
I'm great, Judge. How about you?
Pretty good, thanks.
Good. Sorry to keep you waiting.
Oh, it's so. Dismiss the defective equipment on files A and B and the no proof on C. 235's the total, and I'll give them until August the 10th to pay this, okay?
That's excellent. Thank you, Judge.
Have a good day.
You too.
Is that one resolved, or what are we doing on that one? Or am I just setting it for a trial?
We're just gonna adjourn it. I need to review discovery.
I know, but he's been here multiple times. We're paying an interpreter every single time. I know. Well, I just,
I haven't seen the video at all to discuss.
Okay, well, give me that file. I just hope he understands he's paying the interpreter fees when we're done. People against, David Istelart Gonzalez, 25W836565. So when we get these, I gotta get these out of here first. Do you know what I mean? This poor interpreter's been sitting here for 3 hours. I didn't even think it was on my case. And it's expensive, Your name? Yes. I'm sorry? You gotta keep your voice up. We gotta get you on record. Do you have a card for me again, please? Raise your right hand. You solemnly swear or affirm that you will make a true and accurate translation between the court and the defendant.
I do.
So he was arraigned on until July 9th. I'll adjourn it again. Your appearance, Mr. Crawford?
Michael Crawford, representative.
Your name, sir?
David Istelart.
August what, Lisa?
I'm sorry, did you say 2 weeks or 4?
2.
August 6th at 9:30.
August 6th at 9:30. We'll need an interpreter again, okay?
Thank you, Your Honor. We'll be ready.
Thank you very much. Thank you. August 6th at 9:30. Thanks. You can go down the hall and get your notice. Thank you very much.
Good.
totally fine. Like, love it, love it, love it. Can I ask why?